morning, everyone. Here we will formally call this session of the court to order, and we will start first case, which is Francis Smith Williams Jr. versus the people of the Virgin Islands, number 68 of 2019. Ready?
Mr. Chief Justice, I may please the court, Kelechukwu Chidi Onyejekwe. I represent Francis Smith Williams Jr., who was an officer of the Virgin Islands Police Department. I reserve 5 minutes for rebuttal.
Very well.
Francis Williams is serving a 90-year sentence imposed upon him by the Superior Court of the Virgin Islands. Was found guilty of murder, manslaughter, and stalking. We will now ask this court to vacate those verdicts, reverse the judgment of the Superior Court, with instructions for the Superior Court miss counts 2 and 4 of the information. There are 4 reasons for this. First one is that the court violated Williams' right to a jury trial when the court instructed the jury to find him guilty of murder simply because a firearm was used in the killing. Secondly, contrary to the decisions of this court and of the United States Supreme Court, the Superior Court convicted Mr. Williams against inconsistent verdicts of murder and manslaughter within the same count, and that is within the same counts of count 2 and count 4. Thirdly, and this may not matter actually, but I've written it, Officer Williams at the time was an officer of the Virgin Islands Police Department, as I said. 14 VIC 2251 does not operate against him at all. And finally,
what section was that?
14 VIC 2251.
2251.
And finally, stalking is a crime that was enacted in the Virgin Islands and in other jurisdictions to prevent death and serious bodily harm. In this case, however, the government waited until death had occurred to try to punish Mr. Williams of stalking. In the process, they failed to prove at trial that Mr. Williams followed another human being, or he followed a person as required by statute.
If I understand you, you're saying that once a person dies, the stalking, it has to disappear?
Yes, Your Honor, because this is not just a constitutional requirement, it's a requirement of the philosophy of positivism. When people are born, they have a birth certificate. When they die, they have a death certificate. When this court, a Supreme Court of a state, of the country, rules about something, it is the law of the country or of the state. These are requirements of positivism. So it's not something that is new to our judicial system.
Attorney Keeley, I got a series of questions. You know that they were coming. The first one is if somebody stalk a person today and the stalk E, it dies 2 days from now. The stalker is not charged with what happened 2 days from now, but the date and time of the stalking. And if the person was alive at the date and time of the stalking, then the crime is committed then. Whether the person subsequently dies makes no difference, because you know what would happen under that theory? Nobody would be able to be charged with murder because the victim would have been deceased. So, of all intents and purposes, the charge is stalking on certain days and when the person was alive. And the fact that he's charged after the person is deceased or he is found guilty after the person is deceased makes no difference. Now, you mentioned 2251. Are you suggesting that because he's a police officer, he cannot be charged under 2251?
That's my argument precisely.
All right. Look at 2253.
Unfortunately, Your Honor, I did not have my rule book.
All right. Well, let me read it for you.
I did address.
Right, there's a crucial difference between these two sections. 2251 says, whoever has possessed, bear, transport, carries, or has under his proximate control, and then it goes all the way down and it talks in terms of, or any other dangerous or deadly weapon. There's absolutely no argument that a gun that was created just to kill or maim is a dangerous weapon. But if you go over into 2253, it says whoever, unless authorized by law. Now, he was authorized by law to carry a weapon as a police officer. But look at the original information and the amended information. Nowhere is he charged with a 2253, which talks about unless otherwise authorized by law. Therefore, since there was no clarification under 2251 with which he's charged, which is whoever has possessed, bear, or any other dangerous weapon during the commission or under his proximate control during the commission of a crime of violence or whatever, then it is clear that he was charged under the correct section as a police officer, which is 2251. Now, it is clear to me that when you have a 2251 section and a 2253, which is the only thing that separates them is just 10 pages in the VI code, it is clear that there was an intent by the very language that it should be treated differently, the two sections. And so be it in this case. And remember now, he is authorized to carry a weapon in furtherance of legitimate police action and in furtherance of his duties and responsibilities and within the scope of his employment. I don't think that the department is authorizing officers to carry a weapon to commit murder upon other people because of personal issues. Officers are not supposed to carry in terms of use a weapon to kill somebody when they have a personal disagreement or dispute or argument with that person. But let me ask you this. You said something which is you want us to reverse the entire case, the entire charges. Am I correct?
Yes.
But suppose we find sufficiency of the evidence and that other verdicts were legitimately considered by the jury and the verdict was imposed by the jury. Why should we reverse when there is no cause to reverse, when there is sufficient evidence to support some of the charges? Those charges don't have to be retried at all. Only those charges in which you might find some shortcomings or some error in that would warrant reversal or remand for a new trial. Not those in which he was legitimately convicted.
There is no,
But just to clarify, you're saying that we should reverse counts 2 and 4.
you should reverse counts 2 and 4 with instructions for those counts to be dismissed. You should,
Attorney Onyekwe, the notice of appeal in this case lists 7 issues. Which of those issues did you brief?
which of the issues did I brief?
Yes, sir.
All of them. Some of them not as directly as others.
Well, what you indicate in the issues that you have briefed is that the issue was raised in other words in Williams. And what you point to in the joint appendix as pages 44 to 63 are the judge's memorandum of law denying the Rule 29 motion. None of the issues that you are raising before this court were raised before the Superior Court. So why should we consider them?
You should consider them because this court has a rule, Rule 22M, that requires this court to consider them. Whether the court decides to act upon them or not is a different matter. The United States Supreme Court in United States.
You're saying that we should consider them under the plain error standard.
You can consider them under plain error standards. That's my argument.
All right, and if we do consider them under the plain error standard, where do you address substantial prejudice? Because that's a necessary prong if we consider them under the plain error rule.
With respect to counts 2 and 4, we rested our argument in substance on this court's decision in People versus Wallace. In People versus Wallace, it was a similar argument. We did not go out and say the error is substantial or not specifically, but we did address the fact that the court applies the plain error doctrine. But I was saying earlier that under Wells, United States versus Wells, the Supreme Court of the United States says that appellate counsel is free to raise this argument anytime they come up, and it's a legitimate argument to free the client. And this court has cited United States versus Wells. This court, in fact, has a rule mirroring United States versus Wells. So the idea that because an issue was not raised below, somehow it's abandoned, it's inconsistent with this court's own rules. It's inconsistent with multiple decisions of the Supreme Court of the United States.
Let me ask you, Andre.
All the rules that we have regarding notices of appeal and briefing are really inconsequential, according to your argument.
No,
according to the case that you are citing, we should, regardless of our rules, overlook them and consider any issues that were raised before the Superior Court, that were not raised before the Superior Court.
Your Honor, the Superior Court, in fact, the government does not concede that at trial, Williams raised the issue of prejudice, of sufficiency of the evidence. And we are saying that the evidence is not sufficient because, number one, there is no evidence of malice in this case. And the government's brief, I believe, appellate's brief at page 15, does concede that this argument was made. So
you're saying that the court's instruction that you can infer malice from the surrounding circumstances, including the use of a deadly weapon, you're saying that where there was evidence that at least one of the shell casings from his gun was found at the scene, and both officers are shot in the head, that you're saying that there is no evidence of malice?
But that's not the instruction. Your Honor, the instruction.
Well, I know what you're saying with the instruction.
Yeah.
The instruction. But tell me why you think that the court in this case, as you say, demanded the jury to infer malice from the use of a firearm, of a deadly weapon, actually. When you look at the instructions as a whole, wasn't it permissive that the jury may infer, even though in one instance it says that malice is inferred from? When you look at all of the instructions, isn't it clear that, the jury had the option to infer malice?
No, in fact, this court instructed the jury 5 times. All the instructions regarding malice were incorrect or incomplete. I read from the joint appendix as 1467. It says malice is inferred when the killing is accomplished by the use of a weapon or other instrument in such a manner as to naturally and probably cause death. That's just one of them.
Let me just ask you this. Defense counsel requested an instruction on voluntary manslaughter, correct?
I didn't hear that, I'm sorry.
The defendant requested the instruction on the lesser included of manslaughter, correct?
Yes.
And requested that instruction, and the court granted the instruction.
Yes.
And there was no objection to the instruction.
That's correct.
And when the judge read the instructions, he actually asked, is there any objections, any corrections? And counsel said no. Now, why should we consider that?
Well, you should consider it because it is not the obligation of defense counsel to amend the complaint or the information. Earlier during the proceedings, the government had in fact...
Should you be able to request an instruction, get that instruction, and then on appeal complain about the instruction?
Yes, as I said, the United States Supreme Court has rejected this notion that you couldn't in the United States versus Wells. And Mr. Chief Justice, you have cited to that opinion in a concurring opinion of yours. So that idea that you can't...
But don't you have to go through the plain error standards? And with all of the opinions that we have written saying that you can infer malice from a deadly weapon, how is that error plain to the trial court?
In fact, I looked around the 50 states. There is no state, no person given that instruction that you can infer malice just because of the use of a firearm or any other dangerous weapon. In fact, some states have banned completely, as I cited in my brief, giving that instruction when you also will give the manslaughter instruction, because when you do that, you negate essentially the juror's obligation to find the facts.
Well, let me ask you this, Attorney Keeley, because much has been said about malice and malice aforethought. Murder talks in terms of malice aforethought, not malice. Look carefully at the same pages, 1466 and 1467 in Volume 3. And the judge said malice is inferred, then he talks about that, but he talked about malice aforethought. And he said malice aforethought may be inferred from the circumstances which show a wanton and depraved spirit. And the element of the crime is not malice. It has to be malice aforethought. On the way to malice aforethought, you may peripherally talk about malice, but the fact is that did he not give the proper elements when he addresses the issue of malice aforethought and not necessarily malice. Malice was thrown, I guess, as something extra. But does him saying that, when you look at the totality of the circumstances, the factual scenario, all of the jury instructions, and when in fact that malice is not part and parcel of the element of murder, but he addresses the element of murder, which is malice aforethought, and he said that you may discretionarily, you may infer from the circumstances which show a wanton and depraved spirit, a mind bent on evil mischief without regard to its consequences. Malice aforethought does not mean, and then he defines malice aforethought means simply such and such hatred or whatnot. So, and all the murder counts, he talks and he defines and gives the jurors what is malice aforethought and how it may be inferred. Well, the fact that he said malice is inferred and malice is not an element of the crime, does that still mean that when he said that malice can be inferred when the use of a weapon, does that rise to the level of plain error warranting a reversal of the murder, of the homicide convictions?
Yes, Your Honor, because the judge, the instruction, there is nowhere, I didn't see anywhere in the instruction where the judge instructed the jury that it may do this or it may.
Oh yes.
It says that
He didn't read the general instructions then.
It's right on page 1466 and 1467. Where, right under when he talks about malice,
okay,
he then talks about malice aforethought. And that's where he indicate malice aforethought may be inferred.
I have 1467 here, and in my
Attorney Kelly, look at that. You've gone over 11 minutes, so sit. You can discuss that in your rebuttal.
Okay.
But look at it carefully, Attorney Kelly, because he said he made that distinction on all the counts between malice and malice aforethought, and malice aforethought is the element of the crime.
Counsel?
Morning, Your Honors. May it please the Court, Assistant Attorney General Kenneth Case on behalf of the people. The case is no doubt a tragic story involving the loss of not 2, but 3 Virgin Islands police officers' lives. Of course, there were the lives of Officers LL and Javois, who were gruesomely murdered 5 years ago on the beach in St. Croix, but also that of the appellant, whose decision to commit that heinous act now means he must spend the rest of his life in prison. However, make no mistake about it, appellant is not there by accident. He was given his day in court. In fact, he was given 7 days. His lengthy trial was the culmination of 3 years' worth of investigation involving not only the Virgin Islands Police Department, but also the FBI and ATF. The evidence presented to the jury consisted of testimony from dozens of witnesses and nearly 100 exhibits. Eyewitnesses provided background on the events leading up to that night, and experts took to the stand to give detailed explanations of the crime scene investigation and forensics evidence that was recovered. In the end, after hearing all of the evidence, both for and against the appellant, the jury concluded that the people had proven their case beyond a reasonable doubt, and that appellant was in fact guilty of the horrible crimes with which he was charged. Appellant now seeks to have that verdict overturned by appealing multiple issues to this court that were never raised in the court below. Appellant does not cite to the portions of the...
Attorney, I have a question because the defense has made much ado about this stacking issue. But looking at all that transpired and all that is recorded in these 3 volumes, whether it be at the hideout bar, whether it be him taking her keys, whether he going to the house, whether he's staring at her during the time of the graduation ceremony, and him texting her and sending her messages which he refused to accept, the encounter they had at the bar, which called for the intervention of other officers in order for her to get away from him, because this isn't like you start 1 day or 2 days. This seems to be a continuous, ongoing set of activities And then when he went down and Frederick stepped down by her house and tried to run Jovis off of the road with a police car when he saw his white Wrangler. And if he didn't take evasive action, he could have injured all of. Looking at all of that, those circumstances where she break off the relationship, she in essence is telling him to go fly a kite, she now have somebody, and all that he did, would that rise to the level of stalking? Because if it does not, then nothing else will.
Absolutely, Your Honor. I mean, I think the people showed through the use of, the witness testimony, the pattern that occurred with this stalking. I mean, like you said, it was over a lengthy period of time.
Systematic pattern over a period of time.
Correct, over a lengthy period.
And it only stopped when she died.
Correct.
Well, he couldn't stalk her then. But when you're going to charge stalking, does the death of the victim or the stalkee has anything to do at all with it? Or do you charge based on when the acts occurred, what subsequently transpired in terms of the death of the stalkee or the victim? Does that nullify, negate, or obliterate the stalking?
No, the charges would relate back to the time that the act occurred, and obviously at that time, I mean, Officer LL was a person, and we're not saying she's not a person now. I mean, she's a person at all relevant times. So, yeah, absolutely. That does not. The fact that she's now deceased does not negate any of the stalking charges.
Yeah, but the other thing that in the defendant's brief, he raised the issue concerning the expert witnesses. But my best recollection of the record is that Jovis was shot 5 times.
Correct.
One was a headshot. And the casing that was from 16 feet from his head was retrieved. And that matched the weapon of the defendant.
His service weapon.
His service revolver service issue. What is curious about that is that, number one, no in the record did he report it missing or stolen. But even more egregious was that it was retrieved from where? His house. When the police went there and he came out, and his brother brought out the service weapon. Now, do you know anything about St. Croix, Santa Cruz, about Hans Bluff and that area? I don't
Been
know.
to St. Croix. I don't believe I've been to Ham's Bluff before,
okay.
but
would have to take somebody that took his weapon at some point in time, go down on Hans Bluff, shoot him at least 5 times, at least once we know of because of that, and killed him, and somehow get back the weapon and give it back to the defendant. Because no matter what transpired, we can't get away from that casing that was retrieved from the crime scene that pinpoint to his weapon and his weapon alone. Was that sufficient evidence in terms of that linkage?
I think that absolutely links him to being at the crime scene and the use of his weapon, which, I mean, only he had access to. So, absolutely, I believe the jury could certainly reasonably find that he was there and committed this act.
Would he have had any motive for killing these people?
I mean, the motive that, from the witnesses that testified was essentially that he was a estranged lover. I mean, he had been in a relationship with her for 2 years. She was now in a new relationship with Officer Javois. I mean, his demeanor in the weeks prior was, he clearly was upset with that relationship, and eventually, it reached a boiling point where, unfortunately, the events that occurred.
It wasn't just the relationship that irked him. What irked him was he bought the ring to marry her, went to her mom, to her mother, and that he make it clear that he wanted to marry her, and she would marry him, but she is seeing Jovis, who is a fellow officer, and she is, she's lovey-dovey with him.
It's somebody that he thought was a friend prior to that, so I think that
Well,
also.
he said he was a very close friend, and they used to work together.
On a case,
Yes.
defendant really makes two, I think, serious arguments at least bid to get the second-degree murder charges overturned. And one is that the court instructed the jury that malice is inferred from the use of a deadly weapon. And he claims that all the other courts have always made it, optional. The jury has to be told that they don't have to find it. They may infer it. In this case, the court, and the general instructions made it use the word may, but in the elements, it said clearly malice is inferred when the killing is accomplished by the use of a weapon or other instrument in such a manner to naturally and probably cause death. And the defendant is arguing that that is an instruction to the jury that you must infer it. How do you respond to that? And is that in fact removing that element from the jury by telling them that it is in fact inferred rather than they may infer it?
I don't believe so, because what the case law makes clear is that we need to look at the jury instructions as a whole. And
but where the court instructs on the elements, and it makes that a mandatory element.
Yes, I understand that, and I think that if an objection had been made and the judge denied that, and we're here on an abuse of discretion standard, maybe there's something to that. But here, under plain error, when you have the correct definition, even though there may be a slight conflict, like I said, we have to look at the whole jury instructions, and the correct definition is in there as the definition of malice aforethought. The portion that's contained in the
He is
counts.
arguing that under our rule, which says that where it's not objected to, the court may consider it where it affects a party's substantial rights. And
Well,
certainly if
I think in
someone-
the Saldana case, this court does say in the Virgin Islands malice aforethought, and then it's defined.
I know
and-
that it says
Yes.
that,
Okay.
and I'm wondering, in light of that actual language in Saldana, it obviously could not be a plain error on the trial court to use that language. So without an objection having been made, how do we even get through the elements, the requirements for plain error review? But to the extent that he is arguing that it did remove that from the jury, and the jury therefore did not have to decide an element, and he's saying that is grounds for reversal because it does affect his substantial rights, because without that, obviously hasn't gotten a fair trial. His argument, how does the government respond to that? People.
Again, I don't think the province of the jury was invaded here, because the general instructions give the jury the option. It says they can consider the use of a deadly weapon. They don't have to. And it also defines the word infer to, again, mean, it's something that they can consider, but again, they don't have to. So in two instances in the general instructions, the court gave the jury the ability to make that decision on their own.
In other words, malice, which is the cornerstone, which is the pivotal issue raised by the defense, is not an element of the crime. It's malice aforethought.
Malice aforethought, correct.
And the judge on pages 1466 and 1467, he definitely used may be inferred. May be inferred. That's the element that we are dealing with, malice aforethought. Whether it's unfortunate that he threw in malice in there separate and apart, but it doesn't go to the element though. If he had only had malice alone and never had malice aforethought, but notice carefully that in each instance where he talked about malice is followed, malice aforethought, he talked about malice, or where he talked about malice, it's immediately followed by malice aforethought, which is the element of the crime. Does it make any difference that even if malice was error in saying that, the fact that it is not an element of the crime, but malice aforethought is an element of the crime, and on the same page as like 1466 and between 1467 and 1468, he tells the jurors what malice aforethought is, or how it may be inferred in a discretionary fashion. Does that in any way negate any possibility of plain error by him using malice and talking about malice, which is not an element of crime? Does it in any way negate that? That the fact that he had malice aforethought correctly said
Right.
about the discretion, but he used malice as directional is inferred, but malice is not the key in the crime or element of the crime. Does it make any difference? Does that rise to the level of plain error when in fact that the correct element is immediately given either before or after the possible error that the defendant is talking about?
Right, and that is our argument, that does not rise to the level of plain error, and as well as the fact that there's no prejudice here, because there's multiple other instances or evidence.
There's no prejudice where, someone is in jail for 90 years and whether or not they're properly convicted on that particular second-degree murder count.
I'm saying that.
Anyway, let me ask you before
Yes.
your time runs out. The issue of the inconsistent verdicts.
Yes.
The judge instructed on second-degree murder. The defendant requested an instruction on manslaughter, and the court granted it. Jury convicted him on second-degree murder,
Correct.
and then also convicted him on manslaughter. Now, my verdict forms would always have that if you find guilty on bigger crime, then you don't, you skip the other question and go on. You only go to the lesser included if you find him not guilty on the lesser. In this case, obviously, that wasn't done, and the jury convicted him on both. And of course, they gave the same malice instruction, and those are not the same elements, correct? Because you have the heat of passion.
Yes, I believe there was a portion of the jury instructions that did say if you find guilty on the greater charge, then the elements on the lower charge are met. If I recall correctly in the jury instructions, I believe that was in there.
I'm not talking about instruction, I'm talking about the verdict form, because obviously
No.
the jury went ahead and convicted him on both. And he is saying that those two verdicts can't stand. So, how do we address that?
Well, I believe that's what the Supreme Court in Powell, they say that inconsistent verdicts are not something that the courts shouldn't delve into the minds of the jurors as to why they were done. I mean, he got the benefit of being acquitted on the first-degree murder charges, and now he's asked to have the manslaughter charges added in the hope that they may convict him on manslaughter instead of second degree. What the Supreme Court in Powell says is that he shouldn't now be able to benefit from both having that lesser charge in there and being able to attack it on appeal.
No, I think that you missed the issue, because this is troubling. What is troubling is I'm looking at the order of judgment and commitment entered by the court on September 12, 2019. I said, count 2, murder in the second degree. He's found guilty. Then they go to the lesser included offense of the crime charge and come to voluntary manslaughter. He's also found guilty.
Right.
Well, it's usually if you're found guilty on the greater charge, then there's no need to go to the lesser charge. And all, as the chief said, and I totally agree, I would always tell my jurors years ago, when I was in the territorial court and the superior court, if you find the defendant guilty of second-degree murder, then you do not go to the lesser included offense at that point in time. Only if you find him not guilty on murder too, can you consider voluntary manslaughter. But the jurors here charged him and found him guilty of both.
Manslaughter, which does not require the same malice, because here you have heat of passion and other things that basically, if you're found guilty on the lesser charge, how can both stand? Because with one you're finding, malice aforethought, and with the other, you're finding that he didn't have that malice aforethought. So I guess that is the...
Okay. Yeah, I mean, the only way I could potentially rationalize it is perhaps the jurors were looking at the evidence from different perspectives, and they decided that if we look at it from one perspective, then we believe there's enough there to find malice aforethought, and if we look at it from another perspective...
I have seen another case law that says that if you're found guilty of the greater crime, then you almost have to dismiss the lesser included offense.
Is there case law? Was it? I'm sorry.
I don't know. I'm saying,
Yeah, because I have seen things that I have read where they would say that you only go to the lesser included offense is basically if the greater offense, because they are merged.
Well, would 104 come into play, which says basically that the defendant can be charged and found guilty on numerous charges, but at sentencing they can be sentenced on more than one? Would that somehow rescue the...
I mean, I think the closest thing that I found was the Hughes case. In the footnote to that, which I think is cited in my brief, it said that a conviction on voluntary manslaughter as a less included offense may stand, even absent evidence of a sudden quarrel or heat of passion, as long as the evidence was sufficient to convict defendant of the greater offense. So I think that's the closest.
On the sentencing is where it comes in. I believe that 104 talk about, all right, he found guilty if a person found guilty of the greater and the lesser, but on sentencing, you got to sentence him on only one. Am I correct? That's what 104 says?
Oh, on sentencing? Yes, that would be my understanding on sentencing, yes.
Okay, thank you. John Keeley, you got 5 minutes.
I do not want to overflog this issue. The court asked me to look to see whether I can look carefully to see whether there's a general instruction regarding whether the court has said the jury may do. The word may does not appear in what I saw. On my brief at page 18, I quoted the general instruction. I quoted malice afterthought at page 1461. I also quoted in my brief.
Well, let me ask you though, on 1461 it says, to act with malice aforethought is to act with a depraved spirit or mind bent on evil or mischief without regard to the consequences. Malice can be inferred from the circumstances, including the use of a deadly weapon in the commission of the offense. Do you see the word can in there?
Yes.
Okay.
And that's the problem.
That means that the jury can or cannot. They can decide what they want.
That means that they can do that.
Right.
It's not that they may decide to do it, but they can, according to this, they can rely on one thing.
Well, can't they?
No, they can't. They can't
Cannot
rely
infer
on
it?
They can't
If
just.
they find from the evidence that You know, isn't that what all the instructions say, as long as the jury has the option?
Jury has the option, and the court has clearly told them they have the
And they
option.
can use that option. It doesn't say, I know in the element where it says, you know, malice is inferred, you're taking issue with that, but
Okay.
isn't can or may infer is not all the same?
No, Your Honor. Can means that they can decide merely on the basis of the use of a firearm, which is that's not the position of the law, according to this court.
Jury, they can, but they don't have to. And I think
But
that's what that optional language is, may, can.
Now, the court, there's clearly, if the court stopped there, I would concede that there may be some ambiguity. Then the court goes on, and in the must prove section of the instruction tells the jury, you must, in substance, find that the use of a firearm.
Must. Don't quote it to the court. The court never
Honor,
uses must.
may I please
It says all it says is that it is inferred, and even that is not telling the jury that they must infer it. It says it is inferred from it, and if the other one's saying you can infer it, this is that it is inferred. But
the appellee's brief says that on page 14 appears to understand this as the court instructing the jury to find Mr. Williams guilty on the basis of this killing on the basis only. The appellee told this court, or in his brief, that the only difference between this case and Wallace is that, unlike Wallace, in this case, the Superior Court instructions expounded upon the concepts of malice aforethought and inference. Appellant's argument unfairly isolates such one fragment of the overall jury instructions.
that's what they're arguing here today, that you just can't take one, you look at the instructions as a whole, and if the jury is properly instructed when you read all of the instructions, you don't pick out one sentence and says that is a basis to reverse.
But all these instructions in Wallace were also given in this case. That's the point I'm just trying to make. He's saying that the Wallace court didn't give these instructions. The Wallace court did give these instructions and more. Inference, malice, they did give that. So
Attorney Keeler,
there's no, yes.
yes, since your illustrious opposition colleague raised the issue of 14 VIC 104, this is a catch here because you raised it also about inconsistent verdict. An act or omission which is made punishable in different ways by different provisions of this code may be punished under any one of such provisions, but in no case may it be punished under more than one. So basically, if in fact that the voluntary manslaughter is a lesser included offense of second-degree murder, and if in fact under the judgment here and commitment, they have count 2 found guilty of more than the second degree, and the lesser included offense of voluntary manslaughter. So it's a matter of, even if it's inconsistent, if we invoke 104, all that means is that he could only be punished under one of them, but not under both of them. Am I correct?
Well, our primary argument is that because in the same count you have manslaughter and you have murder, our primary argument is that must be dismissed because you can't charge him with that. You can't try him again.
Well, which one do you dismiss?
Both of them.
No, you can't dismiss both of them. He was found guilty. He was found guilty of both. And if we invoke 104, it says, but in no case may he be punished in under more than one.
The statute says that when when the court can't, it's not clear, the court should go with the lesser, the
You're-
the lesser degree.
They always
You'll
go with
argue the rule of leniency.
Yes.
basically.
the-
All right,
they-
thank
they
you.
always go with the greater crime.
Thank you. The matter is submitted.